The seatbelt sign just turned on. The pilot's voice comes through the speakers. 20 minutes to landing. Local time in the United States is 6:43 in the morning. You have been traveling for 16 hours. You are tired. Your back hurts. You are ready to be home. You reach into your bag and pull out your documents. Green card, passport, return ticket stub. The person next to you is doing the same thing. You fill out the customs declaration form. Everything is straightforward. You have nothing to declare. You have been abroad for 3 weeks visiting family. You are not worried. You have done this before. You know the process. But what you do not know, what most returning immigrants do not know, is that CBP changed what they are checking at ports of entry in 2025 and expanded it again in 2026. It is not just your passport anymore. It is not just your green card. There are new database checks running in the background before you even reach the officer's booth. There are new questions being asked at primary inspection that were not standard 2 years ago. And there is a specific list of things that, if said the wrong way or not said at all, can send you to secondary inspection for hours. Most returning immigrants walk through those airport doors having no idea what CBP is actually looking for right now. What immigration attorneys charge $350 per hour to brief clients on before international travel is sitting in this video. Stay with me. I am Jacob, and I reviewed the official CBP Port of Entry Processing Guidelines DHS entry verification procedures updated in 2025 and 2026, and the specific authorities CBP officers operate under per the Immigration and Nationality Act. Everything here comes directly from cbp.gov, dhs.gov, and the INA. Before we go through this, CBP procedures at U.S. airports are changing faster right now than at any time in recent memory. CBP does not notify you personally when a new check is added to the entry process. Subscribe and turn on the notification bell so updates reach you before your next flight lands. And join our WhatsApp community. The link is in the description, where we share confirmed CBP and immigration updates the moment they are verified, not after they have already caused a problem at the airport. Now let me show you exactly what CBP is checking and exactly how to move through it. Here's what is actually confirmed under federal law and current CBP policy. U.S. Customs and Border Protection officers at airports operate under authority granted by INA Section 235, which gives them broad power to inspect any person seeking entry into the United States, including lawful permanent residents returning from abroad. That authority has always existed. What expanded in 2025 and 2026 is the technology and the data layers that CBP now runs against your identity before you reach the inspection booth. This includes biometric matching through facial recognition at participating airports, currently active at over 30 major U.S. airports as confirmed by CBP's Biometric Entry-Exit Program documentation. It includes expanded checks against the Terrorist Screening Database, the National Crime Information Center, and foreign government data sharing systems under bilateral agreements DHS has formalized with multiple countries since 2023. Here is what is being shared on social media that is not accurate. There are posts saying that CBP now has the legal authority to permanently revoke a green card on the spot at the airport without any hearing or appeal. That is false. Under INA Section 240, lawful permanent residents have the right to a removal hearing before an immigration judge before any final removal action can be taken, with narrow exceptions for certain criminal convictions. There are also posts saying that CBP officers can demand access to your phone and that refusing means you will be detained indefinitely. That is not accurate. The legal framework around device searches at the border is specific and your rights in that situation are real. Knowing the truth about both of these protects you far better than the panic version circulating in group chats. Now let me break down what CBP is actually checking and what your rights are at each stage. The first check is biometric identity verification, and it begins before you reach a human officer. At airports participating in CBP's Biometric Entry-Exit Program, which includes JFK, LAX, Miami, Chicago O'Hare, Houston, Dallas, and more than 24 others, your face is scanned as you approach the customs and border area. This scan is matched against your passport photo, your visa or green card photo on file, and DHS biometric records. For most travelers, this takes under 3 seconds and requires nothing from you. But if the biometric match returns a flag, a mismatch, an identity discrepancy, or a hit on a watch list, you will be directed to a secondary booth before you reach primary inspection. You will not necessarily be told why at that moment. What you should never do at this stage is argue, raise your voice, or ask to skip the scan. CBP officers at this stage have no discretion to waive the biometric process. Stay calm, move as directed. The process itself is the protection. It gives you the right to proceed through proper channels. The second check is the primary inspection interview, and this is where most returning immigrants make the mistakes that extend their wait or trigger secondary referral. Under INA Section 235A, every person arriving at a U.S. port of entry, including green card holders, is subject to inspection by a CBP officer. The officer will ask you a set of questions. The questions may include Where are you coming from? How long were you outside the United States? What is the purpose of your trip? Do you have anything to declare? Here is exactly what to say and what not to say. Answer each question directly and briefly. If you were visiting family, say, I was visiting family in your country for your number of weeks. If you were on a business trip, say, I was traveling for work and I returned for your number of days. Do not add information that was not requested. Do not explain the details of your family situation. Do not mention any immigration proceedings that are not directly relevant to this entry. Immigration attorneys charge $325 per hour to coach clients on exactly this interview preparation. You now have the same framework, but the primary inspection is not the only check that matters. The third check is the travel history review, and this one specifically affects long-term green card holders. CBP officers now have real-time access to your complete U.S. entry and exit records through the Advanced Passenger Information System and the expanded Entry-Exit Overstay database. If you are a green card holder and you have spent significant time outside the United States, particularly more than 6 months in a single trip or more than 12 months cumulative over recent years, that travel pattern will appear in the CBP officer's system. Extended absences can raise questions about whether you have abandoned your permanent resident status under INA Section 316 and related regulations. What you must never say at primary inspection is, I have been living mostly outside the U.S., but I keep my green card current. That single statement gives a CBP officer documented grounds to refer you to secondary inspection for an abandonment inquiry. If your travel history involves extended time abroad, the correct preparation before your trip, not at the airport, is to consult with an immigration attorney about whether you need a re-entry permit issued before you leave. A re-entry permit, filed on Form I-131 before departure, provides documented protection against abandonment findings for absences of up to 2 years. Bringing that permit with you when you return is the difference between a standard inspection and a 2-hour secondary hold. Consider what happens when a returning green card holder does not know this. A 63-year-old permanent resident returns after spending 8 months abroad caring for an ill parent. She has her green card. She has her passport. She answers the officer's questions honestly, mentioning that she has been away for 8 months. The officer refers her to secondary inspection under INA Section 235B for an abandonment inquiry. She waits 4 hours. She is asked to sign a form she does not fully understand. She signs it. The form is an acknowledgement that affects her case record. That outcome, the signing, was completely avoidable with one sentence. I am not signing anything without speaking to an attorney. The fourth check is the device search authority, and this is the one causing the most confusion and fear in immigrant communities right now. CBP officers have the legal authority under border search doctrine, confirmed by federal courts, to search electronic devices at the border without a warrant. This applies to phones, laptops, and tablets. However, there is a critical distinction between a basic search and an advanced search. A basic search means the officer manually looks through your device. An advanced search means the device is connected to external equipment for deeper data extraction. Under CBP Directive 334049A, an advanced search requires reasonable suspicion or national security concerns. A basic search can be conducted without suspicion. If a CBP officer asks to look at your phone, you are legally permitted to say, I do not consent to a search of my device. However, and this is critical, refusing a device search at the border does not carry the same protection as refusing a search inside the country. CBP can detain you for a longer inspection period and in some cases can hold your device temporarily. The legal landscape here is still developing. What you should never do is have content on your device, social media posts, messages, photos, that you would not want a federal officer to see, because at the border, the threshold for a basic search is extremely low. The fifth check is the public charge and financial records review that now applies more specifically to certain visa categories and adjustment of status applicants returning from abroad. If you are on a visa, not a green card, and you are returning after having used any means-tested public benefits, CBP may ask about benefit usage as part of public charge admissibility review under INA Section 212A-4 as updated by current DHS policy. For green card holders, this check generally does not apply at the airport unless you are re-entering after abandonment proceedings. But for visa holders, benefit usage history is now part of the admissibility review in ways it was not 3 years ago. Here's your exact step-by-step plan for arriving at a U.S. airport in 2026. Step 1. Before you travel internationally, check your total time outside the United States over the past 2 years. If any single trip was over 6 months or your total absence approaches 12 months, consult an immigration attorney before you leave about whether you need a re-entry permit on Form I-131. Step 2. On the plane, fill out your customs declaration form completely and accurately. Declare everything you are required to declare. An incorrect declaration is a federal offense that creates a separate problem on top of any immigration issue. Step 3. At the biometric scan area, cooperate fully and move as directed. Do not ask to skip the scan. Do not raise your voice if you are directed to a secondary area. Step 4. At primary inspection, answer questions directly and briefly. Say exactly this for the standard questions. I am a permanent resident returning from a visit to your country. I was there for your number of weeks. I have nothing unusual to declare. Stop there. Step 5. If asked about time spent outside the U.S., state your actual travel dates factually. Do not volunteer interpretations of what those dates mean for your status. Let the officer ask follow-up questions if they choose to. Step 6. If referred to secondary inspection, go calmly. When you sit down with the secondary officer, say exactly this. I want to understand what this inspection is about. I am cooperating fully. If I am asked to sign anything, I would like to understand what I am signing before I do so. Do not sign any document you do not understand. You have the right to ask what a document says before signing. Step 7. If at any point you are told you may be subject to a removal proceeding or expedited removal, say only this. I am a lawful permanent resident, and I am requesting a hearing before an immigration judge. Do not sign a voluntary departure form. Do not waive your hearing rights. Do not agree to leave the country without speaking to an attorney. Here are the free resources that support everything in this video. CBP Traveler Information and Entry Requirements, cbp.gov, Reentry Permit Information Form, I-131, USCIS.gov, ACLU Border Rights Resources, aclu.org, Know Your Rights. National Immigration Law Center, nilc.org. Immigration Legal Aid by Location, immigrationadvocates.org. BIA Accredited Representatives, justice.gov, EOIR Recognized Organizations, USCIS Main Line, 1-800-375-5283. One important warning before I close. There are people selling airport and border crossing coaching packages to immigrants, charging hundreds of dollars to tell you what to say to CBP. The information in those packages is either available free from the ACLU and NILC, or it is dangerously oversimplified. No paid consultant can guarantee how a CBP officer will respond to you. No notario has authority at a port of entry. If you have a real concern about your entry, a complex travel history, a past immigration issue, or a pending case, the only person who should prepare you is a licensed immigration attorney or a BIA accredited representative, not a paid social media coach. Legitimate attorneys charge for their time, but they never guarantee outcomes at the border. Now I want to hear from you. Have you been referred to secondary inspection at a U.S. airport? Did you know about the biometric scanning program already running at your airport? Drop your experience in the comments. And tell me, which country did you fly in from most recently? Which state do you land in? Your question may become the next video on this channel. I am Jacob. You have rights in this country. Knowing them is not defiance, it is protection. Take care of yourself.